Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzelli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. Alright, here's a quick favor you can do for yourself. If you're even thinking about your case management setup, go take a look at this. E-Immigration is offering listeners of the podcast a free demo, and when you book through the podcast link, they'll donate $25 to Casa Cornelia Law Center in San Diego. And yes, there's a bonus. Everyone who signs up will also get a free upgrade from the Essentials package to complete. It's a win-win, so go to get.eimmigration.com/IRP. Check out a ton of free resources and book your demo today. Or of course, click on the special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and is intended to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Welcome. I wasn't going to do it, but I'd rather do this than talk about the ICE deaths and scary proposed regulations put forth this week. How about that BIA call for amicus, huh? I gotta hand it to them. That is, Republican administrations. They know how to wield power, and they give no you-know-whats. Amicus request on this question, quote, is the Board of Immigration Appeals bound by Supreme Court of the United States or applicable circuit court precedent on issues of constitutional law, even in situations where an application of that precedent would require the board to find a statute or regulation unconstitutional, end quote. Not really sure what they're thinking about, but I don't know, maybe Mahmoud Khalil and I&A Section 237A4C? Whatever it is, amazing stuff. And this from the party that believes administrative agencies are too powerful. Can't wait to see where this goes. Enjoy these cases, everyone. Starting off with Fulton v. Mark Wayne Mullin et al., published by the Second Circuit on July 14th, 2026. This case is about preventing people from dying in ICE custody. Judge Menashe dissented. Mr. Fulton has end-stage renal disease. Now, I'm only a Juris Doctor, but it seems to me that the phrase end-stage likely means he doesn't have much time left. Suffers from other serious, compounded medical issues as well. He is detained in ICE custody, and he filed a habeas petition in federal court, but a district court judge denied that petition. The appeal of that is on appeal with a separate Second Circuit panel, it appears. So he filed papers in the Second Circuit to order his release pending a decision from the other panel, which is considering his habeas petition in chief, where he's considering a similar, albeit more permanent, relief. Look at that litigating. Lucky for him, the Second Circuit's got a very good decision in this area from 2001, Mapp v. Reno. Quote, in order to be entitled to release, Mr. Fulton must demonstrate that 1. His petition raises substantial claims, and 2. Extraordinary circumstances exist that make the grant of bail necessary to make the habeas remedy effective. End quote. Mr. Fulton has committed attorneys, likely working pro bono, and they also filed a stay of removal for him. Seems like he has a final order of removal, too. To get a stay, federal courts must consider similar but definitely not identical factors. And well, he got his stay from, I guess, a different Second Circuit panel. And in the stay decision, the stay panel held that he'd raised a substantial claim that he'll be able to succeed on the merits of his removal challenge. The Second Circuit majority reads that to rule that he made, quote, at least a substantial claim that the district court improperly dismissed his for medical discharge planning relating to his life-threatening medical condition, end quote. Now, I'm not going to lie. I don't completely follow, and the decision's a tad cryptic. Maybe Oyl was really arguing jurisdiction, so that's what the panel means here, given their jurisdictional cite and parenthetical. I don't know. But whatever, we're past it. As to the extraordinary factor, well, quote, as the government does not dispute, failure to supply adequate medical care will result in Mr. Fulton's near certain death, end quote. And yet, DOJ's still fighting this case. Gotta be hard to be a DOJ attorney in immigration sometimes these days, guys. Now, in dissent, Judge Menashe, former associate White House counsel for President Trump, quote, claims that not even the government dares to suggest that Mr. Fulton's circumstances are not extraordinary enough because he has adequate medical care in custody, end quote. The majority explains, however, that this ignores that Mr. Fulton has already almost once died in ICE custody because of this condition, and that less than a year ago he was referred for a kidney transplant, which he cannot get in ICE custody. ICE won't even, let him go to a hospital for the transplant temporarily with a guard or something, it seems. Pretty incredible, as written. Nor does the majority believe, like Judge Menashe, that Mr. Fulton should take this opportunity to save his own life by simply accepting his removal and thus getting a release from ICE custody. Specifically, Judge Menashe states that Mr. Fulton, quote, has the keys in his pocket and can end his detention immediately because he can simply deport himself, end quote. Couple of things wrong with that to the majority. 1, no one disputes that he can't get the needed dialysis if deported to his home country, meaning he will die. So by the way, America is paying for his dialysis in immigration prison instead of just releasing him. But 2, no one disputes that he can't coordinate the necessary, urgent post-deportation medical care that he needs from detention. And 3, is this really what we've come to? That's me, not the court. Quote, if there was ever a case in which an immigrant detainee had no keys in his pocket or anywhere else besides a court of law, it's this one, where Mr. Fulton faces a serious risk of rapid physical deterioration, and the government has not even suggested that he present a risk to the community or a flight risk, bail pending appeal is appropriate, end quote. So the parties need to agree to conditions for release, or the court's probably going to just do it for them in a week. And in fairness to Judge Menashe, while I didn't read the dissent, I did skim it, and he does have more facts and some reasoning that dulls the cruelty as reflected in the majority just a bit. But with the big win for humanity, congratulations Jessica Rolfe from the Rutgers Constitutional Rights Clinic, as well as Anthony Enriquez, Sarah T. Gilman, and Sarah Decker of the Robert and Ethel Kennedy Human Rights Center in New York. And that is Fulton v. Mark Wayne Mullin et al. Allow me to please now take you through a journey through the Board of Immigration Appeals, which does seem to be getting more and more extreme every week. The first decision that we're going to do is a matter of NERS, published by the BIA actually last week. It's the first of 2 ACA decisions that came out last week that no human in their right mind could have possibly done because we live in the craziest case law time period. And it's the shorter of the 2. The ACA, of course, being that horrible asylum cooperative agreement, that wonderful terror of Stephen Miller's mind's creation. Don't want to think what else is in that mind, though, so pro se non-citizen graciously providing the vehicle for the BIA to make non-citizen adverse precedent. Of course, in the context of a once rare but totally not rare anymore interlocutory appeal, at least when it's DHS filing it. The non-citizens here are asylum seekers from Venezuela. DHS doesn't even want to give them a chance to try to establish eligibility for relief, and so moved to pretermit their asylum applications in court, saying, hey, we have an ACA agreement with Ecuador, so we'll send them to Ecuador. On January 27, 2026, the immigration judge denied that motion to pretermit, concluding that DHS failed to show that the respondents are subject to the ACA with Ecuador. Specifically, the IJ found that DHS did not provide the required implementing instrument, showing the operating procedures for the ACA or the, quote, complete set of operative terms and criteria, end quote, to show that the respondents are subject to the terms of the agreement with Ecuador. That is what the BIA has beef with here. IJs are supposed to rubber stamp things when DHS brings an ACA motion to pretermit. The BIA will debase itself infinitely to this end if you haven't figured it out yet. Here's how it works, explains the BIA. DHS files its motion. Then simply because of that, the burden shifts to the non-citizen to prove that the ACA agreement doesn't apply to them. Of course, they can get no discovery, and the BIA's interpretation of the regulations and statute in recent months has made it such that non-citizens can do almost nothing to meet their burden. Here, as was argued for some time in immigration court, it appears that the U.S. reached an agreement with Ecuador but didn't actually take steps to implement the agreement. So, there was no guidance or, proof that pretermitted non-citizens would actually be sent to Ecuador? Not making it up either. After all, the ACA itself provides that, quote, the parties shall develop operating procedures to assist with the implementation of this agreement through a subsequent instrument, including, among other things, clear criteria to determine eligibility for transfer to the Republic of Ecuador, as well as necessary bilateral assistance to implement this agreement, end quote. Well, to the BIA, whether the ACA-defined operating procedure is actually created is none of the IJ's concern under the ACA regulations that the Biden administration did not vacate. Not actually a core part of an ACA agreement either, just subsequent. Rubber stamp, remember guys? That is the theme. What happens next to say the detained, now ordered removed non-citizen who has been barred by an immigration judge from bringing an asylum claim is none of the IJ's concern. The BIA wants to be really, really clear about this. That's literally it, too. That's pretty much the decision. Lovely stuff. And that is a matter of NERS. And there's more. Matter of EARM, published by the BIA last week. And wouldn't you know it, Mr. EARM is pro se too. And of course, it's an interlocutory appeal from DHS. The BIA goes out of its way to note that this pro se family of asylum seekers didn't file a response to DHS's interlocutory appeal. By the way, I didn't say the ACA regulation in the last decision. These ACA pretermissions are traveling under 8 CFR section 1240.11h. And here it's a Venezuelan asylum seeker family that the U.S. government wants to send to Ecuador again. Although one of the adults is actually from Colombia, the mother and child are from Venezuela. The respondent's argument here was that, quote, the ACAs are impermissibly retroactive and that Ecuador is not a safe third country, end quote. That latter argument is totally viable. It's just the BIA has already done all humanly possible to ensure that IJs can't really give it much consideration. That first argument, though, we're about to learn why it's not viable. In response to the motion, the IJ issued a scheduling order requiring DHS to state many things so that the IJ could make a decision on the motion. DHS chose not to comply with the IJ's scheduling order. Because of that, the IJ denied DHS's motion to pretermit, concluding that because DHS has not provided notice of its intent to remove the respondents to Ecuador for the adjudication of their asylum and protection claims, there's no disputed issue for the immigration judge to resolve, and therefore no need for the IJ to determine the applicability of the safe third country bar. In the alternative, the IJ found that he could not determine whether the ACA with Ecuador applies to the respondents, and it would be improper for him to designate Ecuador as a country of removal. These were things that the IJ specifically ordered DHS to respond to and to provide a statement about. It was error, though. IJs can't act like judges with ACA agreements. First, a bit more about the Ecuadorian ACA agreement specifically. Quote, the ACA does not apply to unaccompanied minors, Ecuadorian nationals, or habitual residents of Ecuador, end quote. And for all ACAs, quote, the regulation applies only prospectively to non-citizens who arrive at the U.S. port of entry or enter or attempt to enter the U.S. between ports of entry on or after November 19, 2019, and provides a general mechanism for implementation of all existing and future ACAs not previously implemented, end quote. So there's that. The Biden administration did not vacate that regulation, and we are stuck with it now. And it looks like the BIA only thinks IJs can consider three things when faced with an ACA agreement. 1. Whether the agreement does not apply to the respondents or preclude them from applying for asylum. 2. Whether the respondents qualify for an exception specified in the published Federal Register document setting out the ACA and its exceptions. And 3. Whether the respondents have demonstrated that it's more likely than not that they'll be persecuted on account of a protected ground or tortured in Ecuador. Prior precedent has precluded IJs from requiring DHS to demonstrate that Ecuador is willing to accept the respondents, and further explains that IJs do not have the authority to determine whether the respondents will have access to full and fair procedures in Ecuador, or whether it would be in the public interest to allow the respondents to pursue the asylum claim in the United States. All things that you would think an IJ can do, but you would be wrong. How did the IJ err here? Well, DHS didn't need to provide more notice to the non-citizen than their motion, and an oral motion at a master calendar hearing also suffices. Nor can an IJ inquire into whether DHS really intends to send the people to Ecuador, who DHS is literally asking the IJ to pretermit from applying for asylum based entirely on an agreement with Ecuador. Nor can an IJ inquire into protection procedures in the third country. And again, of course, the lack of an implementation plan is of no consequence. We just learned that. Literally, all you need is the existence of an ACA agreement to take away a non-citizen's right to apply for asylum in America under Trump 2, it would appear. And some of that is directly from this decision. Moreover, and broader than ACAs, the BIA holds that neither it nor IJs have any authority at all to review DHS's stated country of removal. What can an IJ do when faced with an ACA motion? Beats me. Don't despair, though. The IJ here, quote, may adjudicate DHS's motion either by written order or during a promptly scheduled master calendar hearing after considering the evidence and arguments presented by the parties, end quote. And that is a matter of EARM. Moving on, we have matter of LRMC and VAMM, published by the BIA this week. This case is about ineffective assistance of counsel and matter of Lozada compliance. The respondents are a mother and minor daughter from Honduras. The case was remanded to the BIA from the 10th Circuit. The BIA is having none of it. They had an asylum claim denied in 2023 based on an adverse credibility finding and then did not timely appeal to the BIA. The BIA later denied a motion to accept untimely appeal based apparently on diligence and summarily affirmed the removal order. The non-citizens then timely filed a motion to reopen alleging ineffective assistance of counsel against the attorney who didn't file in time. The BIA denied that because the BIA didn't believe there's sufficient proof that the non-citizens had filed a bar complaint against their former counsel, as the horrific matter of Lozada requires. Seems that there is some bar complaint against former counsel present, though, but the BIA isn't sure it actually relates to counsel's representation of the non-citizens here. Pretty strange. The non-citizens then filed a timely motion to reconsider, arguing that proof of mailing the bar complaint, which apparently was included, is sufficient to comply with matter of Lozada. BIA denied that too, quote, observing that the new attorney who filed it worked at the same firm as the allegedly ineffective one, and thus concerns about disclosure or collusion were not satisfied by proof of mailing without proof of the contents of what was mailed, end quote. The 10th Circuit remanded, though, believing it unclear whether this will all suffice for a matter of Lozada claim and compliance. It will not, explains the BIA. So matter of Lozada. Podcast enemy number 1. That decision, nearly as old as me, holds that for motions to reopen based on ineffective assistance of counsel, The movement must 1. Include an affidavit from the respondent setting forth in detail the relevant facts, such as the specific terms of the agreement entered into with counsel. 2. Include evidence that the offending counsel was informed of the allegations and provided an opportunity to respond and any subsequent response from counsel. And 3, quote, reflect whether a complaint has been filed with appropriate disciplinary authorities regarding such representation, and if not, why not, end quote. The BIA just made that all up. It is certainly owed no deference today with Chevron dead, and is different from ineffective assistance claims in every other legal counsel, which, as I understand it, all simply followed the Strickland v. Washington test. And not all circuits require all elements, even in the Chevron deference days, for ineffective claims. But the 10th Circuit, where these proceedings are occurring, apparently approved it all in 2015, if not earlier. The BIA explains that Requirement 1 is, quote, essential to set forth the facts of the claim, end quote. Requirement 2, quote, ensures that former counsel has a meaningful opportunity to reply to the allegations and helps ensure that the BIA can rely upon the allegations as accurate, end quote. If you say so, guys. And Requirement 3? Well, using just the most condescending of rationales, the BIA relays its long-standing rationalization that it, quote, serves to deter meritless claims of ineffective assistance of counsel, but also highlights the standards which should be expected of attorneys who represent non-citizens in immigration proceedings, end quote, using the word aliens for that. And again, not required in any other area of law, which presumably also has high standards. Also, it helps protect from attorney collusion, explains the BIA. And it, quote, preserves the integrity of the entire system, end quote, a factor of the utmost importance to the BIA, again calling these human beings aliens as it does it. As such, and here's your rule, quote, both the contents of the bar complaint and proof of its filing serve an important purpose in ineffective assistance of counsel claims, end quote, and must be filed with the IJ or BIA with such motions. The BIA is concerned with addressing the fact that, quote, a potential loophole exists when the ineffective attorney attempts to avoid official reporting by accepting responsibility in the motion to reopen without filing a bar complaint, or by passing the respondent to a friend or coworker who will assert the ineffectiveness claim but avoid documenting it with the relevant disciplinary authorities, end quote. Maybe so. But also there's the fact that well-meaning, excellent attorneys sometimes make mistakes and care deeply about their clients, and they should not be forced to choose between saving a client's life and destroying their livelihood and reputation through a bar complaint process. Something to consider as the BIA makes up policy rules? Undiscussed by the BIA. The BIA cites Arias v. Bondi from the 8th Circuit, episode 304, in support. To be super clear, quote, to satisfy matter of Lozada's bar complaint requirement, a motion to reopen based on ineffective assistance of counsel must include a copy of the bar complaint filed with disciplinary authorities and proof of the filing of that complaint or an explanation why a bar complaint was not filed, end quote. Good luck with meeting that latter, never explained in a precedential decision, standard though, guys. I imagine this does not all necessarily apply in the circuits that do not require strict Lozada compliance, and particularly of Requirement 3, but who knows, y'all? Who knows? The BIA reminds that reopening is disfavored, and states actually that this is an interim order. The non-citizens have 30 days to cure the deficiency, or the motion to reopen is going to get automatically denied, which, to be honest, might happen no matter what, but who knows? And I literally can't get out of this decision quick enough, but now I must include this. The BIA states that this is an interim order because it's not technically resolving the matter. It will do so after the 30 days that it's giving to cure, it says. Yet every BIA decision since the dawn of time, including this one, has been titled a interim decision. This one is interim decision number 4218. What is the difference between an interim decision and an interim order? Why are all BIA decisions interim? Whoever tells me will receive a shout out. Happy to give a shout out to a BIA member who wants to email me too. Gotta be current though. Don't try to chime in, Homero or Andrea. And that is matter of LRMC and VAMM. We conclude then with matter of Lopez-Davila, published by the BIA. This is an astonishing decision about non-LPR cancellation of removal. Senators should ask Todd Blanche about it at his confirmation hearings, as it is issued in his name. Mr. Lopez-Davila is from Guatemala and has lived in the United States for a long time. He has no criminal history discussed in this decision, though he is detained for reasons unexplained. Perhaps simply because he's Iwi and apparently in the Fifth Circuit? An immigration judge granted him non-LPR cancellation of removal from detention, it seems. DHS appealed, and the BIA has now taken it away. To get non-LPR cancellation, of course, the non-citizen must show that their qualifying relative, spouse, parent, or child will suffer exceptional and extremely unusual hardship absent a grant. Here, the qualifying relative is Mr. Lopez-Davila's 6-year-old U.S. citizen daughter. And Mr. Lopez-Davila is the only person who cares for her in America. His partner, the child's mother, quote, is not capable of caring for their daughter due to a stroke which led to severe physical and cognitive disabilities, rendering her unable to care for herself or others. The respondent's partner has been diagnosed with suicidal ideation and experienced multiple hospitalizations, including, at the time of the hearing, hospitalization in Mexico, end quote. She must not have status, or else I'm sure she'd be a qualifying relative. It's a bit weird there too, unclear, but I guess we'll just move on. Because Mr. Lopez-Davila apparently is an Iwi who somehow ended up in the Fifth Circuit and is detained, his partner's adult daughter has been caring for Mr. Lopez-Davila's 6-year-old child since his detention. But that adult daughter can't do that long term. And so the record establishes if Mr. Lopez-Davila is removed, quote, the child would experience severe hardship and be at heightened risk of being placed into foster care, end quote. Not bad enough, explains the BIA. No mention in the BIA's statement of law that the hardship need not be unconscionable to qualify for non-LPR cancellation of removal. Believing in a mixed question of law and fact, that is, whether the facts equate to exceptional and extremely unusual hardship, the BIA holds that actually, this is all Mr. Lopez-Davila's fault for deciding not to take his daughter to Mexico with him. A daughter who, as a U.S. citizen, has a complete, absolute, and unalienable right to live in America. Quote, if a qualifying relative child would not suffer exceptional and extremely unusual hardship by accompanying the parent, then the fact that the child might face hardship if left in the United States would be the result of parental choice, not the parent's deportation, end quote. Such a rule to me effectively negates BIA precedent and USCIS practice manual guidance that holds that the hardship inquiry is an either-or inquiry and does not require a showing of hardship both if the qualifying relative remains and accompanies the non-citizen. To the extent your circuit has case law that holds the same, and most do, I recommend freshening up on it and to begin citing to it. In any event, maybe the older sister could care for her, reasons the BIA, and children need not necessarily be cared for by parents under immigration law. I don't know, seems weird, as the BIA did not overturn the IJ's fact-finding, right? Seems maybe it's dicta, which the BIA sure has been doing a lot of lately. The BIA discusses matter of racinus a bit. Then, despite not overturning the IJ's fact-finding, so must be dicta, right? The BIA faults Mr. Lopez-Davila for not providing an affidavit about his intent to leave his child behind. Quote, an applicant for cancellation of removal who intends to leave a qualifying relative child in the United States is generally required to provide an affidavit in proof of the arrangements made for the care of the child, end quote. Didn't technically order Mr. Lopez-Davila removed, though, simply remanded. Does this decision stand for the proposition that a 6-year-old U.S. citizen ending up in foster care is not a sufficient hardship for America to provide grace to her parent? You decide. And that is matter of Lopez-Davila. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Concluding with the Fourth Circuit and starting off with Burry v. Blanche, published by the Fourth Circuit on July 14th, 2026. This case is about deadlines. Mr. Burry is from Jamaica. He overstayed a tourist visa in 2015 but eventually married a U.S. citizen. She, however, it appears, became emotionally and physically abusive. She was certainly arrested for such things and charged herself with domestic violence. He, however, was then put in removal proceedings and ordered removed. That was in 2021. He was not physically removed, but exactly 1 year later, he attempted to file a motion to reopen through the EOIR ECAS system. Now, generally, non-citizens only have 90 days to file a motion to reopen. But through the Violence Against Women Act, or VAWA, Congress extended, quote, the deadline to file a motion to reopen to 1 year following the entry of a final order of removal for domestic violence survivors, regardless of gender, and forgave late filings after this deadline where circumstances warranted, end quote. So he's good, right? Because his motion is VAWA-based and he filed it exactly on the 1 year deadline? Not so. Welcome to hell, non-attorney listeners who are not immigration attorneys but who are attorneys and assume that things work smoothly in immigration. Quote, the electronic system rejected Mr. Burry's motion, requiring that the motion instead be filed in paper form. That same day, Mr. Burry's counsel went to the immigration court and attempted to file the motion in person. A clerk at the immigration court refused to accept the paper copy of the motion, end quote. The reason? The clerk said it had to be filed electronically. Now, honestly, I'm not sure who's right here, but it's probably Mr. Burry's attorney. If the removal order is September 2021, proceedings probably started well before then, which would likely make this a paper case, and in insane immigration world, once paper, always paper. But regardless, my goodness, just accept the motion, somebody. To be fair to the clerk instructed counsel to appear at the court the next day to attempt to refile. And who knows, maybe resolve it with the clerk? But counsel didn't return the next day. Kept trying to e-file and then eventually just mailed it, with lots of proof of counsel's timely attempts. Don't get me wrong, it should not have been this difficult, though. Naturally, the immigration judge eventually denied the motion as untimely, and the BIA affirmed. Then the Fourth Circuit denied a stay of removal and ICE deported Mr. Burry. All because EOIR and its ECAS system is actually insane when it comes to how it treats paper cases. But I guess he's coming back because the Fourth Circuit granted the petition. The immigration judge's denial and the BIA's affirmance was a Fifth Amendment due process violation. Going to be hard to show, though, given that motions to reopen are discretionary, and a, quote, statute creates a liberty or property interest when it provides an entitlement to, not merely an expectation of, a benefit, end quote. Which is, of course, what Oyl argued. But that is the wrong framing to the Fourth Circuit. Quote, Mr. Burry does not argue that he's entitled to reopen his proceedings, merely that he has a right to file a motion to reopen them. The INA permits a non-citizen to file one motion to reopen, end quote. And that right is unambiguous, explains the court. So we've got the constitutional right. But was it violated such that he was prejudiced? Well, Mr. Burry provided evidence that both avenues for filing rejected the motion, the ECAS refusal and counsel's sworn affidavit of the clerk's refusal. In light of this, the court has no clue how the IJ and BIA held that the allegation of being prevented from filing was, quote, unsupported by the record, end quote. WTF BIA, in legalese. And of course then, and indeed separately, it appears the court's refusal to accept the motion rendered proceedings fundamentally unfair. Quote, an immigration court cannot prevent a petitioner from filing a motion and then penalize him for failing to do so, end quote. As crazy as it sounds in a case like this, you still gotta actually show prejudice, though. The Fourth Circuit first rejected the argument that the attorney's failure to show up to court the next day and attempt to file through other means kills a prejudice claim. After all, the BIA and the IJ also held that the 1 year had run by then anyway, right? Even if he had showed up the next day, it was past the 1 year. More to the meat of it, the BIA had held that it was all precluded because Mr. Burry hadn't filed his VAWA I-360 petition with USCIS yet at the time that he was trying to reopen. But that is not a requirement of a VAWA-based motion to reopen filing, explains the Fourth Circuit. The statute itself says a motion to reopen requires that the non-citizen submit a, quote, copy of the self-petition that has been or will be filed with USCIS upon the granting of the motion to reopen, end quote. Emphasis by the court and nothing more required, explains the court. One sentence on the most important part to me, though. Oyl didn't dispute that Mr. Burry, quote, articulated a prima facie case to reopen his proceedings under VAWA, end quote. That's where the real prejudice battle is usually fought. And so the Fourth Circuit ruled for Mr. Burry. By the way, in a footnote, the Fourth Circuit postulates that actually maybe the 1-year time period to file a motion to reopen began to run after the 30-day appeal period ran from the IJ, rather than from when the IJ ruled. Because only then, that's when the removal order becomes final, right? After 30 days, when the appeal period ends. So really 13 months instead of 12, meaning that all of this fight is actually besides the point. Interesting observation based on language from the Supreme Court's Riley decision itself. Peek the footnote. And as such, congratulations, law students Siona Sharma, as well as Erica Hashimoto, Max Alderman, and law student Steph Posolidis from the Appellate Litigation Program at Georgetown University Law Center for petitioner, appointed by the Fourth Circuit to this case. And that is Burry v. Blanche. Moving on to Flores-Tercios v. Blanche, published by the Fourth Circuit on July 16, 2026. This case is about asylum. Mr. Flores-Tercios is from Guatemala and entered the United States without authorization in 2016. He applied for asylum on account of his membership in the asserted particular social groups of Guatemalan adolescents and/or youths and Guatemalan adolescents and/or youths who resist gang recruitment because of personal belief. At least for the purposes of the petition for review, those are the groups at issue. He fears MS-13 gang members who assaulted him and threatened to kill him and his family if he didn't pay them. And he was being recruited to join, and he was refusing. He quit school to work to make payments and then fled to the United States when it all became even worse. The immigration judge believed him, but didn't believe any of the groups were groups or that they were the central reason for the harm suffered and feared. The BIA affirmed. Gangs just want to recruit, to crassly twist Cyndi Lauper's words. And the Fourth Circuit affirmed the denial. Even assuming without deciding that the groups are groups, the court doesn't see a nexus. Wasn't about Mr. Flores-Tercios' youth or beliefs to the Fourth Circuit. He himself testified that the gang's, quote, purpose was to make the ranks bigger, end quote, and that they extorted everyone in town. To the extent youth might have played a role, it was incidental at most to the court. The fact that the gang extorts everyone and wants to grow and wants money doesn't preclude an asylum finding if there's another central reason, but that's not present here to the Fourth Circuit. Where the court has so held in the past, listing decisions discussed on the pod, the non-citizen, quote, pointed to some evidence that her protected trait factored into the gang's decision-making and explained why the gang targeted the petitioner and not someone else, end quote. Not so here. Nor was the gang recruitment and refusal to join or pay extortion a precursor to a family member being threatened and successfully applying for asylum themselves, as was the case, for example, in Hernandez-Avalos v. Lynch from 2015. A bit of a common appearance of a case in the Fourth Circuit. Yes, country condition evidence shows that gangs frequently target children and youths, and yes, that is important evidence that can succeed on nexus, explains the court. But nexus is fact and case specific, and not enough of that is present here. Honestly, that testimony about recruiting everyone seems like something the Fourth Circuit is having a hard time getting past. The no nexus finding for asylum tanks withholding of removal too, as the Fourth Circuit is not apparently one of the circuits that has held that withholding of removal has a lower nexus standard. On to Convention Against Torture Protection then, which has no nexus requirement, well. Some important standard of review stuff, which, by the way, should apply to the BIA review too. Quote, the IJ's prediction of how officials will act is a factual question. Whether that conduct qualifies as acquiescence is a legal judgment, end quote. Here, Mr. Flores-Tercios argued that the BIA didn't split up that analysis. It applied de novo legal review type things to the whole analysis, but not so to the fourth. The BIA, quote, discerned no clear factual or legal error in the IJ's determination, end quote, that Mr. Flores-Tercios failed to establish a likelihood of torture with official acquiescence. That's okay because the BIA reviews IJ fact-finding for clear error, at least these days, where the IJ denies relief and protection, of course. Mr. Flores-Turcios, quote, identifies no factual finding that the BIA reviewed too deferentially and no legal question it left undecided. Absent that, the claimed ambiguity is not a basis for remand, end quote. Now, the facts can be challenged, too, before the Fourth Circuit, but the court affirmed the agency. For example, quote, the IJ acknowledged the chronic violence in Guatemala, but noted that the record established that the government generally attempts to control the gangs and that police engage regularly in anti-gang operations, end quote. A finding the court believes supported by the record. And Mr. Flores-Turcios never reported to police. He didn't report out of fear, but the IJ said that means we don't know how police would have responded. Given the deferential review, it's enough to affirm the agency. And so the court did. And that is Flores-Turcios v. Blanche. We therefore conclude with Montesinos Cisneros v. Blanche, published by the Fourth Circuit on July 17, 2026. This is an interesting case about what it means to be admitted in any status. Judge Thacker dissented. Ms. Cisneros is a lawful permanent resident, or at least she was. She first came to the United States without inspection in 1985, and after that she obtained temporary protected status in the 1980s or 1990s. I've never even heard of this, to be honest, but then again, I haven't been around that long. Quote, when the TPS designation for El Salvador ended in 1992, President Bush and later President Clinton delayed the deportation of Salvadorans who had registered for TPS by allowing them to benefit from Deferred Enforcement Departure, or DED, end quote. And DED is discretionary executive forbearance that defers removal for a specified period, end quote. Ms. Cisneros did indeed travel with this DED, and in 1994, a CBP officer or similar in Dulles Airport stamped the word admitted into her passport when she came back, writing, quote, DED until December 30th, 1994, end quote, beneath the stamp. She traveled some more in the mid-90s that same way, but in those returns, the officer just stamped, quote, paroled, end quote. She obtained LPR status through NACARA in November 2006, and I'm not even going to get into all that, and the Fourth Circuit doesn't either. And then she was arrested and convicted in 2012 for falsely identifying herself to law enforcement in violation of Virginia Code Section 19.2-82.1, and then in February 2013 to petty larceny in violation of Virginia Code Section 18.2-96. DHS alleged that was 2 or more CIMTs, making her removable. And that's not an issue in dispute in this case because the Fourth Circuit has previously addressed some of these statutes, and that's just not how it all happened at the petition for review stage. What is at issue is whether she's eligible for LPR cancellation of removal under I&N Section 240AA. To get that, amongst other things, she'd have to have been an LPR for 5 years and have lived in the U.S. after being admitted in any status for 7 years. Service of a notice to appear or commission of a removable offense stops the time. She's got the 5 years in LPR status, but not the 7, if 2006 is the date that the 7 years begins, because it stops in early 2013. She'd be about 6 months shy. But if it begins in 1994, when she got the admitted stamp in her passport through DED, well, then she's definitely got the 7 years then. And she'd be eligible for discretionary LPR cancellation of removal, where an IJ could determine whether she warrants it by looking at her entire history as a person. That's what this case is about. DHS initially conceded that she was admitted in any status for LPR cancellation purposes in 94, but then withdrew that very concession in the hearing that they had conceded it at. An IJ ultimately held that it didn't qualify and denied LPR cancellation, ordering Ms. Cisneros removed. The BIA affirmed, and a split Fourth Circuit has now as well. Now, no deference to the BIA, thanks Sloper Bright, explains the court. But what is status? It's different than admission, explains the Fourth Circuit. Quote, admission is a historical event, the act of lawfully entering the country after inspection and authorization by an immigration officer, end quote. But status is a legal conclusion tethered to a legislatively defined class to the majority, relying on dictionaries to define that term, that is, status. Examples to the majority include, but I suppose are not limited to, quote, immigrants and non-immigrants, refugees and asylees, LPRs and temporary visitors, end quote, etc. Important to the court, however, all statuses are, quote, a creature of statute, end quote. Only Congress can create an immigration status. which right off the bat, I suppose, is going to mean DACA can't be one in the Fourth Circuit, right? And DED isn't one, explains the majority. Quote, DED is not a creature of the INA, but a discretionary act of executive forbearance, a decision not to enforce the law against a non-citizen who has no entitlement to be in the United States and is therefore removable. Forbearance of this kind does not create a status. Indeed, it presupposes the absence of one. The beneficiary of such forbearance remains in the country only at the government's sufferance and no statutory entitlement that he can claim against. End quote. Sounds a whole lot like DACA to me, actually. Something the majority does eventually note expressly in footnote 17, so there's a lot of footnotes in this one. TPS, however, would be a status, that same footnote explains, as it is statutorily conferred. Having so held, the majority rejected Ms. Cisneros' counter-arguments. Strong first one, the Fifth and the Ninth Circuit have held otherwise in Tulo Rubio v. Lynch and Saldivar v. Sessions, respectively. Quote, she contends that because the INA repeatedly refers to both lawful and unlawful statuses, the word status, without any qualifier, must include both lawful and unlawful statuses, end quote. Smart argument. LPR cancellation of removal, of course, simply says any status. But the majority is not convinced. Quote, the issue is not whether DED is a lawful status or an unlawful one. It is whether DED is a status at all. As we have explained, it is not. End quote. Status has a technical meaning to the court, and Ms. Cisneros' reading reads it out. The dissent also accuses the majority of equating status with lawful status, which is something it seems that the Fifth Circuit found persuasive as well in its Tulo Rubio decision. What would be an unlawful status, then, that I guess would nevertheless qualify for the 7 years required of LPR cancellation? Quote, the phrase unlawful immigration status describes a recognized immigration status that the non-citizen unlawfully obtained or has violated. A student visa holder who fraudulently claimed university enrollment to obtain status holds a status that was never lawful. Similarly, a student visa holder who fails to maintain a full course of study still holds a status, albeit one with which she has fallen out of compliance. End quote. Explained by the court, quote, when Ms. Cisneros presented herself at Dulles in December 1994, she may have been lawfully present under DED, but she held no status. None, lawful or unlawful. End quote. Lots and lots of explanation and fighting with the dissent in footnotes. It goes on for a long time. The court goes on for pages, in fact, explaining why it believes it's reading the best, its technical reading of the statute, which has the effect of making this longtime inhabitant of America ineligible for a decently favorable form of relief from removal. And of course, as I mentioned, Judge Thacker dissented. And that is Montesinos Cisneros v. Blanche. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.